What if I told you that they already got paid and still want you to pay again? In this video, I'm breaking down how unjust enrichment applies to debt discharge cases, how lawyers manipulate language to shut you down, and what to do when judges silence your remedy. Now, I've helped hundreds challenge debt collection, foreclosure, and court abuse, and this might be the piece they never wanted you to know. Now, before we dive into this video, this is not legal advice. This is not financial advice. Remember to do your due diligence, please, okay? Consult an attorney if you want extra help. Now, what I'm about to talk about today, an attorney will tell you that these are some of the games that they play, okay? So when you are doing your due diligence, please be smart. Use proper strategy, because at the end of the day, you could research this and this, that, and the third. But what I'm going to talk about is how lawyers and judges pretty much try to manipulate you into thinking that you're doing the wrong thing. Okay, we're going to be talking about the aspect of the semantics that they play in the unjust enrichment. And I think that this is the most important video to talk about because, again, this is where people kind of fall short. They may know all the information, they may know all the language, but what happens is the lawyer they always have some level of, they've seen this before, okay? So they play these games to discourage you and pretty much shut you down, all right? And you voluntarily, unknowingly, voluntarily stop pursuing, okay? So before we dive in, if you're brand new, hit the like button, hit the subscribe button. We are on our way to 40,000 subscribers. Thank you guys for all the love and support. You guys have really been showing a lot of love, man. And I wouldn't be here today if it wasn't for you guys. So it is my duty to make sure that I give you guys as much information as I can to help you guys on your journey. Now, the primary question we're going to talk about is, what is unjust enrichment? Okay, we're going to be talking about the games, about the semantics that lawyers play. We're going to talk about when judges don't allow you to speak and what to say in that system and in that aspect. And we're going to talk about how to combat the system. Okay, so make sure you stick around all the way to the end so that you can get this game. So let's dive straight in. All right, now, what is unjust enrichment? You feel me? Let me pull it up. Unjust enrichment is a legal principle requiring one party to return a benefit unjustly received at another's expense when no other legal remedy like a contract or tort claim applies. Okay? To establish a claim for unjust enrichment, you must prove the defendant received the benefit from you, the benefit was at your expense, and it would be unfair for the defendant to keep benefiting without compensating you. Okay? Simple argument, simple framework. All right? Now, understanding that it's a legal concept that someone receives a benefit from that they didn't necessarily earn nor have legal right to keep. The example that I would pretty much bring up is a debt is charged off or securitized and the collector or servicer was already compensated through an insurance settlement or tax offset, which we talk about for the most part on this page. All right. Yet they still try to pursue you for full payment. That is considered double dipping, and it is unjust enrichment. So the one who unjustly enriches himself at the expense of another must make restitution. Now, this is under restatement of restitution. Okay. Under the restatement of restitution, it says restatement also makes clear that restitution may be legal or equitable or both. Okay. A claimant is entitled to remedy for unjust enrichment, need not blase, blase, blah. It dives deeper. You can pull it up and you can pretty much read all of it here. Okay. But what they'll play is, oh, well, we don't need to tell you this information or whatever the case may be, or doesn't apply. And it actually does, okay? Or where in the law does it say that I can't do this? And again, restatement of restitution, okay? So there is, I wouldn't necessarily call them laws, regulations, whatever the case may be, but there is documentation that they cannot just be doing unjust enrichment or should not be enriching themselves unjustly, okay? It should be fair. You dig what I'm saying? Now let's talk about how lawyers play semantics. Okay, what is semantics in law? Okay, refers to a tactic where a lawyer or a party in dispute narrowly focuses on the precise, technical, or alternate meanings of words to obscure the central issue or argue a uncharitable interpretation of an opponent's point. Okay, while the genuine study of legal language is vital for clear laws, playing semantics is a manipulative use of that same process. Okay. So the purpose of them using this is more of a tactical advantage by misdirecting, confusing, or distracting from the core issue. Okay, to clarify ambiguity, and how to do this legitimately is to clarify the ambiguities and ensure that the correct and consistent application of the law is taking place. Often used to evade a direct question or challenge. Nitpicking the irrelevant or pedantic aspects of word choice can be perceived as trivial or manipulative. Okay, the proper way to do it is employed in statutory interpretation and legal drafting to create clear and precise rules on understanding how the word works, phrases, and grammar work together to convey the intended legal meaning, and can have a significant impact on the case outcome by clarifying the legal definition. Okay, so how they're going to play this, right? When it pertains to unjust enrichment, when you're challenging them on a securitization claim and asking them to prove it, they'll beat around the bush. Okay, they'll say things like unjust enrichment doesn't apply in this debt. Okay, they're gonna say this is not a secure transaction. Okay, they're gonna say you don't have standing to claim that. You dig me? But how you will break it down is you will say you don't necessarily need to say that. You won't need to say that the debt is illegal. You just need to say that their claim is unenforceable because it has been satisfied, securitized, or discharged. Okay? When we're keeping it on it out of it being an illegal, another way to break it down and stop the semantics is that you're not trying to be the creditor. Okay? You are defending yourself against being exploited after the debt was already monetized somewhere else. Okay, you have a right to question anybody that is attempting to exploit you. Okay, we're talking about the exploitation that is happening. We're not talking about me being a creditor or making this a sovereign citizen argument. Okay, and if a third party is trying to collect, ask who is being enriched and who owns the real right to collect. You have a right to ask these things. Okay. You can use UCC 1-203 and UCC 9-210 and understand the restatement of restitution to frame your argument. So really to decode what it is that they are doing, okay? Because when they say that like it doesn't apply or it's not relevant or that's not how the law works or you don't have security interests or whatever the case may be, they are not really disproving your argument. That's a key indicator that they are just dodging it using legal jargon, semantics, and presumption. Okay, they're trying to manipulate by, trying to be focused on precise definitions or not. Okay, another thing to highlight is that them saying that unjust enrichment doesn't apply is false. You understand what I'm saying? Because if they pretend unjust enrichment only exists in contract law or business disputes, but in reality, it's a universal principle that shows up in debt collection, foreclosure, overpayments, satisfaction of debt by third parties. And if a collector, servicer, or lender has already been paid through a charge-off via IRS tax write-off, they've been compensated through insurance or third-party settlement, or transfer the debt into a trust or security, and they still come after you, they are trying to double dip. And that is unjust enrichment, point blank. All right? So don't let them play that game with you. And if they are going to play that game with you, just put it in writing. Don't tell it to me over the phone. Another way to combat, you don't have security interests. That is not the point. I'm not saying that I have security interests, nor am I making it about that. Okay? They'll say, well, you're not a secure party under Article 9, so you have no say. But you are not claiming to be the lender or the creditor. See, when you come from an aspect of you claiming to be the lender or the creditor, okay, they'll try to make it that point, but I'm not making it about this, okay? I'm not trying to enforce a security interest. I'm defending against a false or predatory one, okay? So here's what you can say. I'm not claiming ownership. I'm challenging your standing to enforce a debt that's already been satisfied, transferred, or discharged. This isn't about me having a lien or UCC 105. This is about your right to not be extorted by someone with no legal claim. You get what I'm trying to tell you, okay? I'm not. It's not even about this, extravagant sovereignty argument that we try to come up with. You dig what I'm saying? Another distraction tactic that they'll do is they'll say this wasn't a secure transaction. Well, listen. Well, since we're calling it a lease or an unsecured agreement, none of those rules apply. Well, here's the truth. Substance over form governs the law. Okay? So If they say they sold the debt into a trust, created a financial instrument backed by our payments, or profited off your obligation, then even if it wasn't labeled a security, it still functions as one, okay? Because when it functions at one, that triggers UCC 1-203, okay? C1-203 talks about lease distinguished from security interest. So I was speaking with one of my clients about their rental lease agreement, okay? And this is the game that they play, where they'll say, well, it's a lease or whatever the case may be. It is not a security under Article 9. But they disguise that lease as a security interest, because if they sell it or monetize it, then the rules do apply. Okay? Then we could talk about restitution rights under equity and your right to demand accounting, disclosure, and lawful standing. Someone said, well, this is inequity, or I don't know what equity is, or equity doesn't apply when it pertains to the UCC. Under UCC 1-10103, it says that unless displaced by particular provisions of the Uniform Commercial Code, the principles of law and equity, including the law merchant and the law relative to capacity to contract, principal, agent, estoppel, fraud, misrepresentation, duress, coercion, mistake, bankruptcy, and other validating or invalidating cases, supplement its provisions. So long story short, if there is there's elements of equity that cover up or supplements the UCC if it's not directly distinguished in the particular claim. So if you're challenging equity claims under the UCC, okay, they may come with the argument and say, well, this is not something under the UCC. Well, it doesn't matter, okay, because equity supplements the UCC. You dig what I'm saying? All right. Now, here's the real problem. Lawyers will use language to box you out. Okay. They use legalese to create confusion and strip your voice, right? Not because your argument is wrong, but because they don't want you to sound credible in front of a judge or a jury. They turn legal truth into a legal theater. All right. They want it to be a game. They want it to be a show. All right. You mention debt sold, double payment, standing, or lack of authority, and they say irrelevant, frivolous, and that's sovereign citizen stuff. Okay, why? Because if the court actually listened, the whole case would collapse. Okay, so here's what you will say. Counsel is arguing labels over substance. Whether this debt is labeled secured or unsecured, it is irrelevant because it has been monetized, transferred, or paid by a third-party instrument. I reserve the right to challenge unjust enrichment and demand full disclosure of the real party and interest. If you are not the lawful holder of this obligation, then your claim is based on presumption and not standing. Okay? Now, this particular script, I'll go ahead and drop this in the school community. Tap into the school community on a 7-day free trial. All right? Now, to continue on with this, the other thing I want to talk about is when the judges don't let you speak. So when the judges don't allow you to speak, they'll say things like, you're not allowed to say that. This court doesn't recognize that argument. We're here to discuss whether you owe, not who got paid. Okay? A simple response can be, how can this be a fair proceeding if I'm not allowed to present evidence that the alleged debt has been discharged, assigned, or satisfied by other means? Because you're not just defending yourself, you are asserting your right to due process, full disclosure, and a challenge of standing, okay? So essentially you will want to move with standing and move on the direction of challenging their standing. So let's just expound upon this a little bit, okay? When judges don't let you speak or state your evidence, it is a silent warfare that's happening in the courtroom, okay? So you're standing there ready to speak your truth, ready to show that the debt has been discharged or that the party suing you doesn't even own the debt. And the judge will say, we are not here to talk about that. That is irrelevant. Overruled. Stick to the issue, or worse, you are not a lawyer, so you can't argue that. That is the system preserving its illusion of power. They want you to think that they are more powerful than you, and that is what I call a reverse trust scam. They don't want the record to reflect your evidence, your process, your truth, because once it's on record, it can't not be ignored without bias or misconduct. So it's important for you to not only do that, but you have to say these things are on the record, because they'll manipulate the record, and I heard this from a lawyer themselves, former lawyer, where they'll manipulate the record or not put in key information, okay? It's not always perfect. All right. So you want to make sure you are being clear and the judge is allowing you to speak. OK, so here's what's really happening. The court isn't necessarily saying your argument is wrong. They are saying you are not allowed to bring it up in their frame. Why? Because you are right. It exposes the fraud. 2, because if you're heard, it challenges jurisdiction. And 3, because if you get it on record, it creates liability for them. Okay. What they should allow in every court, even administrative, they have a constitutional obligation to uphold your due process, your right to be heard, equal protection, your right to present evidence, and challenge of jurisdiction, your right to question standing, and then lastly, giving you an opportunity to rebut, your right to dispute assumptions and presumptions. You dig what I'm saying? Now, if you're not allowed to speak, ask questions, or rebut the claim, then that is a denial of due process. And that's ground for a judicial complaint, a interlocutory appeal, or even motion to vacate for lack of jurisdiction or fundamental fairness. Okay, so there has to be a level of fairness in the courtroom. Even the judge may say things moving with legal bias, and sometimes may even push your case through without giving you an opportunity to speak your mind. But you want to be able to at least put out on the record, and I'm going to tell you exactly what you should say. Remember, this is not legal advice. Remember to create your own procedures, and also just use this to get the juices flowing, okay? So what you would do instead of getting silence, when they try to shut you down, don't argue emotionally, go procedural. You dig me? So this is what you can say. For the record, I object. I reserve all rights under UCC 1-308. I have material evidence that goes to standing, dishonor, and the validity of the claim, and I request that it be entered into the record. Then hand in a sworn affidavit of fact, your notice of conditional acceptance, a challenge to standing, a proof of discharge or payment, and demand for a verified claim on the penalty of perjury. Once it is in writing, they cannot ignore, which is why it's so important to make sure that you have all your evidence and your key documents that pertains to your argument or substantiates your claim before you go to court. Okay, this is why I don't rush the process and try to, I'm gonna send in these couple of letters and then I'm gonna take them to court. No, I want to make sure that I win before I go to court. And how you're gonna win? Yes, the knowledge is important that I'm talking about right now, but you win more when you have the evidence. Because if all else fails, hey, I have the evidence here. Okay. You may not win that day, but you will have planted a flag for appeal, counterclaim, or future enforcement. So what happens is, yes, this judge may do you wrong, and they may just push you through, and they may just say that your argument is invalid. But if you give yourself the opportunity to say something, if you have an opportunity at any point to say and to say what your claim is for the record, it will always be there as a paper trail. Okay, so they want you to be quiet. They want you to be confused and act confused. They want you to accept debt like it's God's word, even when it's already been sold, paid, or monetized. And once you speak truth, once you assert your rights in honor and know your standing, the whole game changes. Okay? So here's the final reminder. Judges can't deny you the right to defend yourself. I don't care what anybody says. All right? And if they do, a simple act of, hey, are you denying me my right to defend myself? Okay. They can't lawfully stop you from challenging the standing of the other party or suppress evidence of discharge unless they're deliberately participating in color of law fraud, denial of due process, and bias towards a commercial entity with no lawful claim. Okay? When that happens, you document everything. Even if you're on a losing streak, start creating your documentation. Take note of this, because when you appeal, you're going to bring this up. That's going to audit that case itself. Okay? So when you document everything, you preserve the record, you file your own claims, and you become the creditor in commerce and in mindset. Okay? When I say become the creditor, I'm not trying to make it about a sovereign citizen thing. When you understand that you bring more value than what they lead you to believe, that's when you understand who you are in this system. Okay, we are partners. We are not even I'm not indebted to you. Okay, you don't have authority over me. Okay, the only reason you are able to really participate in commerce is literally because of me. Okay, so how about we just move in that aspect and stop trying to make me believe that you are bigger or more authoritative over me than anything else. Okay, so we're going to talk about the use of affidavit of truth, conditional acceptance, and proof of discharge as evidence. Okay, you want to move and say, hey, I move to challenge standing and demand the court recognize my right to rebut the presumption of liability. Now, to wrap this up, because we've been going for about 20 minutes, here's some tools to combat the system. Okay, conditional acceptance. We talk about this in every video. You are demanding a proof of lawful claim. Okay. Under the law, you can do this. It's called a presentment. Number 2, you can demand for accounting under UCC 9-210. Under UCC 9-210, it pretty much allows you to challenge where and if the money was charged off, set off, or in other words, they made money and use your original note as a financial asset. Number 3, you can challenge jurisdiction or standing using affidavit of status, using notice of discharge, finding proof of securitization or charge-off. Charge-off information can be on your credit report, and you can use that as evidence. You can ask them for a 1099. You can also go to the sec.gov, look up for any filings under that company's name, okay? You reserve your rights under UCC 1-308, and you assert constructive trust or unjust enrichment when payments were made to an authorized party, okay? So, this is the energy you must have in order to play the game. Number 1, this isn't just about law. It's about power, language, and control. Okay, they're going to play this game so that they can assume power over you. They'll use the language to manipulate you and ultimately control what direction that you make. Okay, when they use terms you don't understand, they win by default. Your job isn't to out-lawyer them. It's to speak in truth, commercial clarity, and lawful standing. Now that we kind of understand this, number 1, we're not going to let lawyers, judges, or anybody kind of play this game on us, okay? We're not going to move with emotion. Yes, absolutely. They may put you in a position where you are confused, you are stuck, but that's okay. Just make sure you are solid on your evidence and your record. Make sure that you are moving to challenge standing and lawful authority over debt being discharged, or if you should be getting money, or whatever the case may be. This is a strategy to understand how they're going to manipulate you so that they can win. Okay. Now, if you want to learn more about this, down below I have my school community. You can join for free for 7 days for the first 1,000 people. Okay. We're getting close to 900 members, so definitely tap in. Okay. Number 2, if you want to work with me one-on-one specifically about fixing your credit, getting funding, or more importantly, starting your own business, tap in with that one-on-one mentorship, okay? Number 3, tap in with me on all my platforms. The link will be in the description. Down below, if you want to get your credit report, you can get it for free down below as well. The link will be in the description. And if you've gotten this far, man, remember to hit the like button. Remember to hit the subscribe button. Remember to turn on the post notifications, because we do post Monday through Friday. My object and goal is to really free us from the matrix. And this is my way, okay? By shifting our understanding about debt, shifting our understanding about contracts, and shifting our mindset towards these commercial obligations and how to use it to our advantage, okay? This is not the only way that one can become financially free. This is just a piece of financial literacy. Continue to learn more. Continue to do your due diligence. Continue to think outside of the box, okay? If working a 9-to-5 is thinking in the box, think outside the box and figure out, okay, how can I convert my skill sets in my 9-to-5 to be able to do my own thing? That's how simple getting closer to financial freedom is, using your brain and thinking, okay, I have these skill sets. How can I make money with these skill sets without having to clock in, okay? You do that enough, and boom, now you are able to expend your energy more efficiently and use that energy to make money. And maybe you won't have to always do debt discharge and things of that nature. Maybe you won't always have your back against the wall where you're going to court and this, that, and the third. But this is another way. Whether you're going to make money by expending less energy and using your energy wisely, or you're going to learn the game of consumer law, learn how to be able to stop predatory claims and predatory debt collectors, or whatever the case may be. But if you've gotten this far, comment the word discharge. I love you guys, and I'll see you in the next one. This video is sponsored by the Fund Yourself Academy. My step-by-step system designed to help you fix your credit, get funding, and build real financial freedom from scratch. If you're tired of feeling stuck, overwhelmed, or just ready to stop living paycheck to paycheck, this is where it changes. Inside the academy, I break down everything from consumer law secrets that they don't teach in school to how to remove negative items and boost your score, get access to business funding, and start building multiple income streams online. Whether you're just starting out or ready to level up your game and get the bag, this is your playbook. We've got tools, templates, dispute letters, mentorship calls, private community access, and an exact roadmap I use to leave my 9-to-5 and create time freedom. But only for a limited time, you can get access to the Fund Yourself Academy on a free trial basis for the next 7 days. And then after that, you pay less than $1 a day at $27 a month if you like it. No fluff, just facts and just freedom. Go to the fundyourselfacademy.com or hit the link in the description to join now, because nobody's coming to save you, but you can fund yourself.